Today, I'm going to answer a question that nobody ever really wants to ask. What do I do after a loved one passes away to make sure their wishes are carried out? I'm estate planning attorney Sean Eyestone, and even after 20 years of getting these calls, it is still one of the most difficult things I have to do, but also can be one of the most rewarding. And when a person's plan is put together right, the assets are aligned with the plan, the family knows what to do to carry out the plan and what to expect, things can go pretty smoothly. However, if somebody has no idea what's in the plan or who's in charge or what needs to be done, it can get really messy really quick. If you are the trustee or personal representative of an estate, the first thing that you need to do is to exert your authority in a friendly but firm manner and to let everybody know that things are going to take a couple of months. You're sort of like the first responder to a traumatic event or accident. Just like those folks, you have to look like you're in charge, take control, and be firm but fair with the people who are there. Sometimes it might take a little bit more firmness than you're used to. For example, sometimes people will be horrible. We've had cases where families have come in and cleaned out an entire house while the trustee was just making funeral arrangements. We had another time where a family member who's not even involved with the estate took the actual urn of ashes from the back of the funeral home during visitation to keep it safe. People will step in, they'll offer to help you do things to clean out the house or help with the vehicle or move things around. But sometimes you might start to see things just wandering off. People take things. So you'll need to know the family and know what to expect and step in and exert your authority. You may even have to exert it very firmly and more firmly than you're used to. If you're not sure what to do, call your attorney right away to make sure what you should do. The next thing that you need to do is to marshal the assets. What this means is you gather up all of the bank statements, investment statements, get control of the house. You may need to call a locksmith to change the locks and forward the mail. So you start to take control of the assets that the decedent had. And then sometimes when somebody passes away, your first call might be to that locksmith to change the locks if you're expecting a high conflict family. And if that family is high conflict, your second call might be to your lawyer rather than notifying the next of kin who might go in and start stealing things. So if you are working on an estate, the first thing you want to do after you exert your authority is to start marshaling the assets and to start exerting some control. You might not have actual authority under a trust for a few days, or it might even take a couple of weeks if your loved one only left a will to give you actual authority. But in the meantime, if you're acting in good faith, you can use what's called presumptive authority to carry out the actions that you think your loved one would have wanted you to take. If you've been appointed a trustee or personal representative of an estate, the third thing you should do is meet with the advisor selected by your loved one. And then if you're comfortable with their advice, follow it, and then keep the beneficiaries reasonably informed of what you're doing. This doesn't mean that every beneficiary needs to get a play-by-play of what's going on, or that they should start getting distributions right away. In fact, in Michigan, you really shouldn't be distributing anything for 120 days anyway, because there's a creditor notice period. For most of our trust, we build in 120 days of breathing room for our trustees to pull things together and get the notices out to the beneficiaries so that they're not feeling rushed or the beneficiaries are not left in the dark about what's going on. The trustee can just say, well, the lawyer says it's going to take 6 months, or I haven't met with the lawyer about this yet, and that'll usually buy you some more time. Finally, if you're not comfortable with the advisor that your loved one selected for you to work with, nothing says that you have to. You can have any reason or no reason for firing these people. It might just be that they don't call you back. Maybe they're too aligned with one of the beneficiaries, or you just don't like working with them, just the way they treat you. Maybe they order you around. Whatever it is, you can terminate an advisor for any reason and then find one that works for you, because it's important that you get good advice so that you can administer the trust the way that your loved one wanted, or the estate the way that your loved one wanted, so that their estate plan actually works. If you recently lost a loved one and you're in charge of managing the affairs of your loved one, or maybe you're a beneficiary who feels like you're being kept in the dark by the person who is in charge, give us a call at the number below and schedule a strategy session with one of our attorneys so that we can help you make sure that your loved one's estate plan actually works.